It is a real pleasure and privilege to be here today, especially to present the results of our scientific research that is related to questioning animal status as an object in contemporary civil law, which is also our lecture today. So the aim of our lecture or presentation is first to elaborate history of the position of the animal in law, particularly in Roman private law, since today's contemporary private law, at least continental European private law, is mostly grounded in Roman private law. Then the position of animal in the Middle Ages, especially in special court proceedings. After that, the examination of contemporary bioethical and jurisprudential debates about animals as rights holders, which is very important for also private law doctrine. Then object in contemporary civil law doctrine, so what is considered to be an object, and in the end, animal status in comparative civil legislation. So animals in Roman private law, first in general. So ever since Roman law, animals have been considered objects or things. At that time, the distinction was made between domesticated and wild animals. So wild animals were treated as res nullius, so nobody's thing or nobody's property. So anyone could catch them and acquire ownership of them. Domesticated animals were considered to belong to the owner as long as they have that kind of habit to return back, so-called animus revertendi. But as soon as they stop doing that, they become also res nullius. And now in particular, so first codification of Roman law or Roman private law were the 12 tables. There is no exact and explicit provision about status of animal in the 12 tables. We have only provisions about animals who will be sacrificed. So by using the legal interpretation, we could say that even at that times, animals were considered as an object. In 3rd and 4th century, an era of influential and important Roman lawyers begins. So Gaius is writing, I will quote, "Wild animals, if domesticated and accustomed to coming and going, fly and fly in, such as deer, swans, etc., are in human possession and thus are considered as long as they tend to return back." So as long as they have so-called animus revertendi, also because on the other hand, it is very questionable and doubtful can animal even have animus at all. Ulpian, for example, is dividing animal into two groups of things. So first is res mancipi, that were domesticated animals, so four-footed animals as oxen, horses, and donkeys, and also res nec mancipi, which were wild animals. The reason is because Romans were much later acquainted with wild animals. And now I would say a very interesting part are Justinian's institutions, because Justinian's institutions are the part of one of the main and most important civil codification in history, that is Corpus Juris Civilis. And one of the first sentences in the institution is, I will quote, "The law of nature," so natural law, "the law of nature is that which she has taught all animals," with the meaning all living beings, so all animalistic living beings. "A law not peculiar to the human race, but shared by all living creatures." So all living creatures are under the provisions of natural law. So that is one of the first sentences. In all other parts of Justinian's institutions, there are explicit provisions that animals are in human possession by the natural law of ownership. So there is a little bit of inconsistency. So the first sentence is that all living beings are, so the Latin word is animal, or in plural animalia, which can be translated as all living beings. So what I want to say, that was an era where there was a big influence of natural law mostly constructed by ancient Greek philosophers such as Plato, Aristotle, Stoics, and also Roman philosophers, for example, Cicero as one of the main founders of natural law idea, but nevertheless there is some kind of inconsistency here. And the conclusion is that that kind of approach that we have today, that animals are considered as objects, so some animals, as Professor said, so some animals that are considered as objects is mostly grounded in provisions of Roman private law. In the Middle Ages, it is very interesting that there were 189 trials conducted against animals as first defendants. So one could say if animal has so-called process or proceeding liability, that it could be considered as legal right holder or subject of law. But these kind of proceedings were in the service of justice, so not law, so they had a religious character. So most of judgment contain a certain exorcist form. So these were proceedings against animal who did some serious damage. So for example, damage to crops, and I would say even in that times we had that kind of discrimination, because most of the animals who were in this proceeding were, for example, snakes, pigs, ravens. So snake as a symbol of evil, pig as a symbol of some kind of as a dirty animal, and raven as a symbol that something bad will happen, and also insects, because even today one of the questions arrived before 2 hours. Even today, insects are not protected by most animal welfare acts around the world. So we also have that kind of inconsistency here. And that kind of anthropocentric or anthrocentric view was present until 19th and 20th century, where biocentric thinkers are expressing their thoughts. For example, Jeremy Bentham, as one of the main founders of utilitarian ethics, who asked one of the mostly quoted questions. So the question is not can they reason nor can they talk, but can they suffer? On the contrary, a libertarian, John Rawls, for example, believes that man has no duty of justice to animals, regardless the utilitarian ethics and that kind of fact that they are supposed to be right holders. But, for example, like Aristotle, like Kant, especially like Kant, he believes that animals deserve human protection, but not using the principle of justice, but the principle of humanity. The second interesting question is the question, of course, of legal personhood, so persons in legal way, because even Gaius considered that law is all about res personae et actiones, so things, persons, and actions or claims. For example, McCormick argues that who is the beneficiary of the law and what is merely a means of achieving some further good is a matter of interpretation and judgment, an example of animal welfare law which may be questionable in that sense. He also states that person must have active ability but also passive ability, so more precisely the possibility of suffering. The third interesting question is some kind of battle between will theory and interest theory, which is not only part of jurisprudence but also part of civil law doctrine. For example, we in Croatia have some kind of mixed theories, so will and interest theories. And for example, so will theories, I will try to sum up in one sentence. So because the animal has no ability to reason things, the animal is not able to express their will. And on the other side, we have interest theories. For example, Kramer, as the most important supporter of interest theories, points out that any attribution of legal rights, the moral status of being to whom the rights are granted must be additionally taken into account, claiming that legal rights, that the holders of legal rights should be animals and, for example, dead persons. So the question is also what are the objects in contemporary civil law. So these are things, property, obligation, and personality rights. So when we are talking about animals as an object, we are talking animals as a thing. So definition of a thing, for example, in Croatian Ownership and Other Proprietary Rights Act is, I will quote, "Things within the meaning of this act are bodily parts of nature, different from humans, which serve humans for use. It is assumed that things are and everything else that is equated with them by law." That kind of provision is also contained in, for example, German civil code and Austrian civil code, so two civil code that had the most influence on, for example, Croatian civil code. But it is very important to say that in these civil codes, so after these provisions, so after this Article 90 and Article 285, there is an exact provision that animals are not things, and that will be further elaborated by Professor Klasicek.
Thank you. So, okay. So as we heard today already, I will not repeat what we heard before lunch. I actually gathered from my research, and please bear with me, I'm new to this theme. This is my first time dealing with animal law and animal rights. If I make some mistakes, don't judge me too harshly. So there are countries that explicitly state that animals are not things. For example, those countries are Belgium, Austria, Germany, Czech Republic. Some of these might have changed recently, so it might have, there might be a mistake here, but it doesn't matter for the purpose of this presentation. So some countries specifically stated that they are not things, but still the regime for things is still used for animals in compliance with the legal and regulatory provisions that protect them. There are countries that do not state that animals are not things, but as Zorana said, they consider them sentient beings, which should be treated as things only to the extent that is compatible with their nature. For example, Spain, Colombia, and France. Then there is a third type of countries which Croatia fits into, and I'm not sure about Finland, but I know Croatia is in the majority of other countries that do not explicitly state that animals are not things and that they are sentient beings. However, from other legislation and from court decisions, it is obvious that animals are not treated as mere property, as laptops or cars or phones. They are treated differently. So I will just give you a few examples of some of those legislations and court case law that I came upon that show that to be true. For example, we already heard something about the US legislation, and what they have a really extensive legislation when it comes to animal protection. But one of the most interesting and in this time of year very important laws are so-called hot car laws, and some states do have those laws. I think some of European countries have something similar. And those laws actually prohibit owners to leave live animals in a locked car in this hot weather. And some of those legal acts even give passerbys the permission to break the window and rescue that animal. Of course, this does not apply to any other type of property. So if you see a laptop or a phone, you will not be able to break the window and rescue that item. However, it applies to something else. It applies to children also. So if you see a small child, it is prohibited. And recently in Croatia, we had unfortunately cases where children died because they were forgotten in hot cars. And it is prohibited, and you can break the window and rescue that child, and you will not be persecuted. Then, for example, we have a verdict. There's something similar about what the previous presentation was talking about in Spain. I think it's from last year, where a couple broke up and they couldn't agree to whom the dog will go, and the judge actually granted them joint custody. So the dog is 1 month with one partner and another month with another partner. No judge would decide something like this about a car or any other type of things. Then, for example, in Croatia, we have a court decision which dates back to 1992 because it was for compensation for damages. In Croatia, and I guess in most of the world, when judges decide for the value that must be paid, they take into account the market value of the item that was destroyed. In this case, a dog was intentionally killed, it was bludgeoned to death, and the owner sued the perpetrator, and the judge did not, when the judge was deciding about the damages, he didn't take into account the market value of the dog, which was non-existent actually, because it wasn't a purebred dog which was bought. But he took into account the value that the dog had for its owner. And in Croatia, it is literally called affectionate price. I guess most countries have something like that. I don't know how you call it, but in Croatia, it's affectionate price. So that shows that the dog was not considered mere property like a broken window or a smashed car or whatever. Then, for example, we found instances about great apes in New Zealand. They are protected as non-human hominids. In Balearic Islands in Spain, Ibiza and Mallorca, you all know it, they passed actually the world's first legislation that could effectively grant legal personhood rights to all great apes. Something similar was decided in Indian Supreme Court that ruled that all non-human animals have both statutory and constitutional rights. So this all shows that in most countries, animals are not considered as mere things because you do not have any of those legislations about protection of most other things, I would say. So we want to leave you with a question that was already mentioned here. Two questions actually, but it all boils down to the one. Should animals be given legal personhood? Should they be some type of new legal person? Sui generis, which is different from humans and which is different from companies. Because companies are also not humans, they are not living beings, they are owned by humans but have a legal personhood. And their legal status depends on their characteristics on the type of a company, or it depends on who owns the company, how many members it has. So something similar might be applied to animals considering their species, their characteristics, their uses. So it's maybe utopian, but maybe we should think about it. So this is it. Thank you.